The issue in Ricci was what the city did or could do when it was presented with a challenge to one of its tests that for promotion, this was not a quota case, this was not an affirmative action case, this was a challenge to a test that everybody agreed had a very wide difference between the pass rate of a variety of different groups. And the city was faced with the possibility, recognized in law, that the employees who were disparately impacted, that's the terminology used in the law, and that is a part of the Civil Rights Amendment that you were talking about in 1991, that those employees who could show a disparate impact, a disproportionate pass rate, that they could bring a suit, and that then the employer had to defend the test that it gave. The city here, after a number of days of hearings and variety of different witnesses, decided that it wouldn't certify the test. And it wouldn't certify it in an attempt to determine whether they could develop a test that was of equal value in measuring qualifications, but which didn't have a disparate impact. And so the question before the panel was the decision of the city based on race or based on its understanding of what the law required it to do? Given Second Circuit precedent, Bushy versus New York State Civil Services Commission, the panel concluded that the city's decision in that particular situation was lawful under established law. The Supreme Court, in looking and reviewing that case, applied a new standard. In fact, it announced that it was applying a standard from a different area of law and explaining to employers and the courts below how to look at this question in the future.
But when you were deciding it, you had precedent from the Supreme Court and from your circuit that basically determined the outcome you had to come up with. Is that correct?
Absolutely.
And if today, now that the Supreme Court has changed their decision, without you having to relitigate the case, it would lay open, obviously, a different result.
Clearly.
Certainly a circuit would be bound by the new decision. Even though it's only a 5-4 decision, a circuit would be bound by the new decision of the Supreme Court. Is that correct?
Absolutely, sir.
Thank you.
That is now the statement of the Supreme Court of how employers and the court should examine this issue.